Good morning, everyone.
Good morning.
How you doing? How you doing?
Your team is here.
Our team is here.
Where is everybody?
We're going to go in the field alone over here. So the Subcommittee on Capital Markets and GSEs will be hereby called to order. Today's hearing is entitled Continued Oversight of the SEC's Offices and Divisions. And without objection, the chair is authorized to declare a recess of the subcommittee at any time, and also without objection, members of the Financial Services Committee who are not members of this subcommittee may, in fact, though, still sit on the dais and participate in today's hearings. At this point, I will now recognize myself for 3 minutes for an opening statement. So today, the subcommittee will continue its efforts to conduct vigorous oversight of the SEC, and in particular, the individual offices which make up the SEC. In the last 2 years, our subcommittee has heard testimony from the directors of trading and markets, corporations finance, enforcement, and investment management divisions at the SEC. So these hearings have allowed us to take a more thorough look at the agency's operations, their rulemaking agenda, and enforcement practices. So why? So that we can better understand whether the SEC is appropriately carrying out its threefold mission to protect investors, maintain fair and orderly and efficient markets, and last but certainly not least, facilitate capital formation. So I welcome our witnesses today. I look forward to hearing that testimony, and I hope between the four of you that are here on the panel, we'll be able to cover a lot of ground in the time we have. If you go back in the year 2000, the SEC's operating budget was about $369 million. Today, the SEC's budget authority for fiscal year 2016 we're in is a little over $1.6 billion. And the SEC has recently submitted a request for fiscal year 27 budget coming up of $1.8 billion. So during much of the time when Congress has been accused of starving the SEC of funds it needs to fulfill its mission, its budget has actually quadrupled and has done so in less than a little over a dozen years. One thing of this fourfold increase is funding coincided with an agency that has become 4 times more effective. Instead, we're likely to look back at this as a period of time when the SEC missed some of the greatest frauds in history, that when it was ill-prepared for the financial crisis of 2008, and when it failed to properly incorporate economic analysis into its rulemaking, and more recently, has oftentimes been complicit in advancing the priorities of special interests. So unfortunately, instead of addressing some of the fundamental structural issues at the SEC, the Dodd-Frank Act has created even more offices within the agencies, 2 of which are with us here today. Dodd-Frank also granted the agency vast new rulemaking authority that the SEC has oftentimes simply struggled with to implement appropriately. For example, while the SEC has made strides towards improving the economic analysis that underlines its rulemakings, there is still much more work that can be done in this area. And so it's not acceptable for the SEC to simply say, well, Congress made me do it, and therefore assume that rulemaking is beneficial in all cases, as the SEC recently did with its pay ratio rule last year. It is also incumbent upon the SEC to clearly articulate a problem, or a market failure, if you will, that the rules are intended to address, which should be obvious, but it's still unfortunately lacking in many of the Dodd-Frank rules that have been implemented. So I'm eager to come here today to hear about the steps the SEC is taking to further improve its economic analysis. Finally, I also continue to have concerns over recent rulemakings related to credit rating agencies. While there's broad agreement that certain provisions in Dodd-Frank, such as the removal of references to credit rating agencies' regulations, were much needed and directly addresses one of the causes of the financial crisis, I worry that many of the other micromanaging rules included in Dodd-Frank have had the effect of further stifling competition in the credit rating agent industry. So again, I want to thank all the witnesses for the testimony, and I will yield to the ranking member for 5 minutes.
Good morning, and thank you so much, Mr. Chairman, for holding this important meeting and all of our participants today. This hearing will continue our subcommittee series of oversight hearings on the SEC. Today, we're focusing on 4 divisions and offices in the SEC: the Office of Compliance, Inspections, and Examinations, the Office of Credit Ratings, the Office of Whistleblower, and the Division of Economic Risk and Analysis, or DERA. All 4 of these offices play a critical role in policing our nation's securities markets. The Office of Credit Ratings oversees the registered credit rating agencies such as Moody's, S&P, and Fitch. The financial crisis revealed the importance of credit rating agencies. Specifically, it revealed the catastrophic consequences that can result when the rating agencies all get their ratings wrong. In response, Dodd-Frank created the Office of Credit Ratings in order to increase the level of oversight of credit rating agencies. One of the principal missions of this office is to ensure that inappropriate conflicts of interest at the rating agencies do not influence the ratings that the firms assign to different securities. The Office of the Whistleblower was also created by Dodd-Frank and is intended to encourage whistleblowers from the industry to come forward with specific and timely information about wrongdoing. In return for tips that lead to significant punishments of over $1 million, whistleblowers are entitled to a monetary reward, which incentivizes industry employees to blow the whistle before frauds get too large and too devastating. Already, this office has received thousands of tips from potential whistleblowers, which is striking. In fact, in 2015, the office received over 4,000 tips from whistleblowers. The Division of Economic Risk and Analysis, or DERA, is the data arm of the SEC. It supports all of the other divisions in the SEC by conducting cost-benefit analysis of potential rulemakings, developing models that help focus the Commission's resources on the riskiest practices, and even calculating the inappropriate punishment, the appropriate punishment for bad actors. Finally, the Office of Compliance Inspections and Examinations, or OCIE, is one of the largest and most underfunded offices in the SEC. It has over 1,000 employees who examine registered investment advisors, broker-dealers, exchanges, mutual funds, and mutual advisors. This sounds like a lot of examiners, but it pales in comparison to the number of market participants that the office has to examine. The office oversees more than 26,000 market participants, including over 12,000 investment advisors, 11,000 mutual funds, 4,000 broker-dealers, 800 municipal advisors, and 18 securities exchanges. As a result, the Commission is only able to examine about 10% of all investment advisors each year, which is a terrifying thought. This means that roughly 40% of investment advisors have never been examined. What makes this even scarier is that in 2015, a whopping 77% of the Commission's examinations identified deficiencies at investment advisors, and 11% resulted in referrals for enforcement action. If those numbers are constant, that means that of the 5,000 investment advisors that have never been examined, a little under 4,000 have deficiencies that have not been uncovered. This is a scary thought for investors who rely on these advisors to manage their savings. So I look forward to the hearing from all of our witnesses today, and I look forward to your testimony. Thank you for your work, and I yield back the balance of my time. Thank you.
Thank you very much. The gentlelady yields back. The gentleman from Virginia, the Vice Chairman of the committee, for 2 minutes.
Thank you, Mr. Chairman. Welcome to our panel. I represent a rural district in Virginia, Virginia's 5th district. It stretches from the northern Piedmont of Virginia to the North Carolina border. As I travel across my district, I regularly hear from my constituents that they are concerned about jobs in the economy and that they are concerned with the seemingly new normal administrative state here in Washington that makes it more difficult for our Main Street and small businesses to access capital and to be successful. While this committee has been laser-focused on producing legislation that would help our nation's small businesses thrive, that would ease the access to capital, and that would build upon the bipartisan success of the Jobs Act, an equally important function is fulfilling Congress's duty to conduct vigorous oversight over executive branch agencies. Just as my constituents are concerned about our ever-expanding administrative state, I too am concerned that the SEC often deviates from its three-part mission to protect investors, to maintain fair, orderly, and efficient markets, and to facilitate capital formation. Hearings such as this allows Congress to exercise its responsibility of proper oversight over how the SEC allocates its resources in fulfilling its three-part mission. I look forward to the testimony of our witnesses, and I thank the chairman for holding this hearing and yield back the balance of my time.
Great. So the gentleman yields back, and now I welcome the members of the panel before us. Your full statement will be made part of the record. You'll be recognized for 5 minutes. I know most of you have not been here before, but you know the drill, I assume. In front of you, you'll be recognized for 5 minutes. In front of you are the lights, which are green, yellow, red. The yellow light should come on when you have 1 minute remaining, so we'd ask you at that time to begin to wrap up, and red light is when your time, not you, have expired. And with that, Mr. Butler, you are recognized for 5 minutes.
Good morning, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. Thank you for inviting me to testify on behalf of the U.S. Securities and Exchange Commission regarding the activities and responsibilities of the Office of Credit Ratings. The office supports the Commission's three-part mission to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. It does this by overseeing credit rating agencies that are granted registration as nationally recognized statistical rating organizations, or NRSROs. In 2006, the Credit Rating Agency Reform Act established the regulatory framework and gave Congress authority to implement a myriad of rules for the oversight of NRSROs. The Dodd-Frank Act expanded the Commission's authority and mandated the creation of an office, the Office of Credit Ratings, dedicated to the oversight of NRSROs. The office's activities generally fall within three areas. First, examinations. Next, NRSRO monitoring and constituent monitoring. And third, policy and rulemaking. Examinations of NRSROs for compliance with federal securities laws and Commission rules accounts for the majority of the office's activities. The Dodd-Frank Act requires the office to conduct an examination of each NRSRO at least annually, and the scope of the annual examinations covers 8 required review areas. Further, the office employs a risk-based approach to exam planning, identifying different risks for different NRSROs. This improves the efficiency and the effectiveness of the examinations as resources are prioritized and focused on areas of higher risk. In addition to the annual examinations, the office conducts sweeps and targeted examinations to address credit market issues and concerns and to follow up on tips, complaints, and self-reported incidents. The NRSROs have been responsive to the staff's findings and recommendations. Many have implemented fundamental changes, such as increasing surveillance activities, strengthening policies and procedures for managing conflicts of interest, adding staff to compliance and oversight functions, investing in multi-year technology initiatives, and enhancing disclosure, transparency, and governance. The annual examinations that are currently underway include a comprehensive review of compliance with the significant new rules and rule amendments that were adopted by the Commission in August 2014, all of which became effective by June 2015. As required by the Dodd-Frank Act, the office prepares an annual examination report summarizing the essential findings of the examinations. In December 2015, the office published the 5th annual examination report. The NRSRO monitoring and constituent monitoring groups within the office gather, analyze, and assess data and identify trends across the industry. NRSRO monitoring conducts periodic meetings with NRSROs and also meets on an ad hoc, proactive basis as necessary to respond to industry developments. And importantly, NRSRO monitoring meets with certain boards of directors, including a separate discussion with the independent directors. Constituent monitoring holds meetings with investors, issuers, arrangers, and trade organizations. The group conducts ad hoc research as warranted by industry or credit market conditions. The information obtained by the monitoring group provides useful input for examinations and for guiding the direction of any future rulemakings. The policy and rulemaking group within the office is responsible for developing rule recommendations, conducting studies, drafting reports, and including those required by the Credit Rating Agency Reform Act and the Dodd-Frank Act. New rules adopted by the Commission in August 2014 address, among other things, reporting on internal controls, conflicts of interest, including an absolute prohibition requiring the separation of sales and marketing activities from analytics, procedures to protect the integrity and transparency of rating methodologies, a requirement for the Board of Directors to approve a methodology before it is used, and standards of training, experience, and competence for credit analysts. The rules also provide for an annual certification by the CEO as to the effectiveness of internal controls and additional certifications to accompany credit ratings, affirming that no part of the credit rating was influenced by any other business activities. While the Commission has broad authority to examine all books and records of an NRSRO and to impose sanctions for violating statutory provisions and the Commission's rules, the Commission is not permitted to regulate the substance of credit ratings or the procedures and methodologies used to determine credit ratings. Thank you again for having me here today, and I'd be pleased to answer any questions.
Great. Thank you, Mr. Butler. Mr. Flannery, welcome to the panel, and you are recognized for 5 minutes. And I didn't say this at the outset, but you got it right, Mr. Butler. Make sure you always push your button on and off. Thanks.
Thank you. Good morning, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. It's my pleasure to be here today to talk about the responsibilities and recent activities of the Division of Economic and Risk Analysis, which we call DERA. DERA supports the Commission's mission through data-driven, high-quality economic analyses. Over the past several years, we have grown from approximately 96 employees in 2013 to a projected workforce of 175 by the end of this fiscal year. By that time, we anticipate employing 88 PhDs, mostly in economics or finance, but also some accountants, and we even have 2 PhD physicists. These PhDs will be supported by 22 research associates by the end of the year. DERA staff also includes a diverse team of other technical experts and professional staff. The division's rapid growth and resultant depth of expertise has allowed DERA to expand its support across an ever-increasing range of Commission activities. Our most well-known function is to provide economic analyses in support of Commission rulemaking and other priority initiatives. DERA economists examine the need for regulatory action, analyze the potential economic effects of the proposed and final rules, and evaluate public comments on those rules. We provide theoretical and data-driven economic analyses of potential new policies and changes to existing policies. We work closely with staff from elsewhere in the Commission, from the earliest stages of policy development through the finalization of a particular rule. In the course of assisting other divisions and offices, staff routinely prepares white papers or staff studies, white papers and other documents that present novel economic analyses of specific policy issues or rulemakings. For example, last year, DERA staff produced white papers relating to the liquidity requirements for open-ended mutual funds operation, the fund's derivatives usage, voluntary clearing activity in the single-name credit default swap market, and another paper on the market for unregistered security offerings. In addition to research performed in conjunction with particular rules, DERA staff regularly publish their research in refereed journals, and staff papers are posted on the DERA webpage to provide the public with access to our current research on financial markets. DERA's analytical capabilities extend not just to rulemaking, but also to risk assessment. We provide financial and risk modeling expertise to other divisions and offices in support of their supervisory, surveillance, and investigative programs. Our data analysis helps SEC staff with examination prioritization and scoping, including providing guidance on which entities to examine and what to look for during the examinations. One example is our broker-dealer risk assessment tool, which was developed in close collaboration with OC staff. This tool analyzes how a firm's behavior compares to its peers to identify anomalous behavior that might indicate risks in broker-dealers' operations, financing, workforce, or structure. We also have a new corporate issuer risk assessment tool developed in conjunction with the Division of Enforcement that allows enforcement attorneys to examine over 200 custom metrics that help them to assess corporate issuer risk by identifying financial reporting irregularities that may indicate fraud. We also work with the Division of Enforcement. During fiscal year 2015, DERA's staff provided expert assistance in over 120 new enforcement matters. Those staff helped identify securities law violations, quantify the harm to investors, calculate ill-gotten gains, and evaluate economic-based claims of a defendant. For cases that go to trial, DERA helps to prepare the Commission's outside experts and to critique or challenge the work of opposing experts. In certain instances, DERA staff have recently testified on behalf of the Commission. None of this work can be performed without high-quality data. DERA thus acts as a central data hub for the intake, processing, and use of data throughout the Commission. DERA's data oversight falls into two distinct but related categories. First, we work closely with other SEC divisions and offices to design data structuring approaches for required disclosures. DERA supports the SEC's data collections and data usage by designing taxonomies, validation rules, data quality assessments, and data dissemination tools to facilitate high-quality data analysis. Second, DERA is responsible for the day-to-day management of many Commission databases. We routinely generate summary information and statistics which are provided to Commission staff within DERA and elsewhere within the Commission. We also develop and refine data sets that are purchased from outside. In sum, I believe DERA staff are delivering high-quality, data-driven analyses that are critical to the SEC's mission, and we look forward to continuing this work in the future. Thank you again for inviting us, and I am looking forward to answering your questions.
Thank you, Mr. Flannery. Excuse me. Mr. McKessie, good morning and welcome to the panel.
Good morning, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. Thank you for inviting me to testify on behalf of the United States Securities and Exchange Commission regarding the responsibilities and activities of the Office of the Whistleblower. The Office of the Whistleblower is a separate office within the Division of Enforcement, currently comprised of 13 attorneys, 5 legal assistants, and an administrative assistant, all of whom are tasked to administer the whistleblower program. The whistleblower program was designed to incentivize individuals to provide the Commission with specific, timely, and credible information about possible securities law violations, enhancing the Commission's ability to act swiftly to protect investors from harm and bring violators to justice. Under the program, individuals who voluntarily provide the Commission with original information that leads to a successful enforcement action, resulting in monetary sanctions exceeding $1 million, may be eligible to receive an award equal to 10 to 30% of the monies collected. One of our primary activities is to evaluate whistleblower award claims and to make recommendations as to whether claimants satisfy the eligibility requirements for receiving an award. We continue to receive a significant number of award claims, including over 120 claims in fiscal year 2015 alone. As of the end of the fiscal year 2015, preliminary determinations and/or final orders have been issued with respect to nearly 400 claims for whistleblower awards. Since the whistleblower program went into effect, the Commission has awarded more than $57 million to 27 whistleblowers, including more than $37 million in fiscal year 2015 alone. The efforts of these 27 whistleblowers has resulted in orders against individuals and companies totaling over $400 million in sanctions, including over $325 million in disgorgement, ordered to be paid to compensate harmed investors. Because all our whistleblower award payments are made out of our Investor Protection Fund, the amounts ordered to be returned to harmed investors have not been affected in any way by the awards paid to our whistleblowers. Thanks in part to the positive attention the program attracted in connection with our whistleblower awards, the number of whistleblower tips we have received has increased each year. In fiscal year 2015, the Commission received nearly 4,000 whistleblower tips, a 30% increase over the number received in fiscal year 2012. Since the program's inception, we have received more than 16,000 tips from whistleblowers in every state in the country, as well as the District of Columbia, and from individuals in 95 countries outside of the United States. Our office is also actively involved with enforcement staff in helping to ensure that employees feel secure in reporting wrongdoing, either internally or to the Commission, without fear of retaliation. In June 2014, the Commission brought its first enforcement action under the anti-retaliation provisions of the whistleblower program, sending a strong message to employers that retaliation against whistleblowers in any form is unacceptable. Through interpretive guidance and amicus briefs, the Commission has expressed its view that the anti-retaliation protections under the whistleblower program extend to those who report potential securities law violations internally, regardless of whether they separately reported the information to the Commission. Additionally, our office continues to assist enforcement staff to prevent companies from coercing its employees not to report possible wrongdoing to the Commission. In April 2015, the Commission brought its first enforcement action against a company that required its employees to sign broad confidentiality agreements in contravention of our Rule 21F17A. This rule prevents any person from taking any action including enforcing or threatening to enforce a confidentiality agreement to impede an individual from reporting information about a possible securities law violation to the Commission. Protecting whistleblowers from retaliation and safeguarding whistleblowers' rights to report possible securities law violations to the Commission continue to be among our top priorities. In the less than 5 years since the implementation of the whistleblower program, we have demonstrated that we can and will protect the confidentiality of whistleblowers, take action against employers who retaliate against or interfere with their employees' ability to report wrongdoing, and award tens of millions of dollars to whistleblowers whose information leads to successful enforcement actions. Given this strong track record, we expect that the Commission will continue to receive high-quality tips that can be leveraged to detect and halt fraud earlier and more efficiently. We fully expect that the whistleblower program will continue to be a game-changer in the enforcement of the securities laws to protect investors and ensure the fairness and efficiency of the marketplace. Thank you again for the invitation, and I'm happy to respond to your questions.
Thank you, sir. Finally, last but not least, Mr. Wyatt, you are recognized for 5 minutes.
Chairman Garrett, Ranking Member Maloney, and members of the subcommittee, thank you for the opportunity to discuss the SEC's Office of Compliance, Inspections, and Examinations, or which we call OCE, with you today. OCE, through our National Examination Program, advances the SEC's mission through examinations that improve compliance, prevent fraud, monitor risk, and inform policy. With a staff of just over 1,000 employees, OCE has examination responsibility for registered entities consisting of more than 12,000 investment advisors, 11,000 mutual funds and ETFs, over 4,000 broker-dealers, more than 400 transfer agents, over 650 registered municipal advisors. We also have oversight responsibility for 18 national securities exchanges, 6 active registered clearing agencies, FINRA, the MSRB, SIPC, and the PCAOB. Recent legislative changes, such as the Dodd-Frank Act and Jobs Acts, have expanded OCE's responsibility to include examinations of security-based swap market participants, including dealers, repositories, and execution facilities, as well as crowdfunding portals. Compounding the challenges in the sheer number of registrants we oversee is the continued growth in the financial markets and the complexity of market participants. In order to maximize the use of our limited staff, OCE is in the formative stages of reallocating examiners to increase coverage of investment advisors. To meet the challenges posed by a registrant population that far exceeds our resources, we've adopted a risk-based framework for examinations, we have increased our utilization of advanced data analytics, and we promote compliance through transparency. We have adopted our risk-based framework to identify business practices or activities which may harm investors. We aggregate and analyze internal and external data sources to find operational red flags in our registrant population. This analysis enables examiners to identify higher-risk firms when selecting candidates for examination and in determining the areas that will be reviewed in the course of an examination. Over the past 5 years, OCE has recruited industry experts, enhanced our technological capabilities, and increased our use of data analytics to further refine our risk-based program. For example, in the last fiscal year, OCE developed a new version of the National Exam Analytics Tool, or NEAT. NEAT enables examiners to access and systematically analyze a year's worth of trading data much faster than we ever could before. Our quants have also developed techniques and technologies that help examiners detect suspicious activity in areas such as money laundering and high-frequency trading. These ongoing efforts will further enhance and expand our capabilities to prevent fraud and monitor risk. OCE strives to improve compliance with federal securities law through greater transparency. We engage in extensive communication and outreach initiatives with the industry and other regulators. Through this process, we provide registrants the opportunity to self-assess and remediate non-compliant behavior on their own. For example, each year, OCE publishes our annual statement of examination priorities to inform registrants about areas the staff believes represent heightened risk and may warrant examination. As outlined in our recent priorities, we are pursuing several key initiatives that are critical to the protection of investors. For example, in 2015, OCE launched the Retire Initiative, a multi-year examination effort focused on investment advisors and broker-dealers and the services they offer to investors with retirement accounts. We remain focused on retirement-based savings because retail investors are faced with a complex and evolving set of factors when making critical investment decisions. Another priority we have announced is cybersecurity. Over the last 2 years, we have conducted examinations to identify cybersecurity risks and assess cybersecurity preparedness among broker-dealers and investment advisors. As another example of our transparency, prior to initiating these exams, we published our intended areas of focus, and after conducting the exams, OC published a summary of our observations. In 2016, we are continuing to conduct cybersecurity examinations, including testing and assessment of firms' access and control rights, data loss prevention, vendor management, and incident response. The final priority I will mention is liquidity. In light of changes in the fixed income markets over the past several years, OC is examining advisors to mutual funds, ETFs, and private funds that have exposures to potentially illiquid fixed income securities. These examinations include a review of various controls, including liquidity management, trading activity, and valuation policies. Thank you for inviting me to testify today, and I would be happy to answer any questions.
Thank you for your testimony. Thank you all the members of the panel. And at this point, I'll recognize myself for 5 minutes to begin questioning. So I'll begin over here, Mr. Butler, with regard to credit rating agencies. So one of the areas that there was actually bipartisan support on in Dodd-Frank was with regard to the removal of references to credit rating agencies 939A. And that was an area actually that I worked with Chairman Frank at the time to get included in the Dodd-Frank and remove references to NRSROs. But despite, and the purpose was of putting that into Dodd-Frank was what? To say that investment decisions should not be, as they had been prior to that, simply entirely relying upon credit rating agencies, right? But we've seen since then, despite the removal of NRSROs, in specific in the regulations, that some pension funds are still including them. Some pension funds are still specifically including the names of two of the large agencies in their investment guidelines. So in 30 seconds, can you say, has 939A been effective as far as what the intention was here?
939A spoke with regard to the removal of references with regard to federal statutes. The SEC has actually worked, although it wasn't the Office of Credit Rating responsible for the removal,
right.
The offices and divisions that were responsible completed the work there, and so all references have been removed from federal statute
right.
In the work that was done.
So, but has that been effective? I mean, I understand that there are certain pension funds who are actually suing the agents, two of the larger credit rating agencies, saying that their opinions in the past were wildly inaccurate on the one hand, but on the other hand, they actually are still using them as far as their investment guidelines, which seems counterintuitive or perhaps opposed to their fiduciary duty. Would you agree?
I'm aware of the fact that there are pension funds as well as state and local laws that require specific references to credit ratings by name oftentimes, or actually by reference to the big three.
And is that a problem?
I wouldn't necessarily characterize it as a problem. I would say that the 939A statute didn't allow for us to do more other than remove references within federal statute.
So that's a good segue. Is there something more that should be done? Either A, that Congress should be doing this in regard, or SEC can be or should be directed to?
939A, as I mentioned, was not within the ambit of what the Office of Credit Ratings oversees. That was the Division of Corporation Finance, Trading and Markets, and Investment Management. I'd be happy
is there
to
anything
take
else that we should be
back.
doing in this regard, in light of my opening position on this?
With regard to the Office of Credit Ratings, we're comfortable with the authority we have with regard to examinations.
I got that. Is there anything else that you would be recommending, though, that we should be doing this in the light of the fact that funds are still relying upon them?
With regard to the Office of Credit Ratings, we're comfortable with the authority we have. Beyond that, I really wouldn't want to comment.
I got you. Mr. Flannery, when it comes to certain regulations, economic benefit analysis in one form or another is conducted by the agency, correct?
Yes.
Right. When you came to the issue of the pay ratio rule, that was done?
Yes.
And in that analysis, did they find that, is it true that they find that they cannot quantify a benefit?
Yes, I think that's right. Ultimately, the justification, the benefit for the pay ratio rule was tied to informing investors about the possible advisability of their say-on-pay votes.
Right, but at the end of the day of that, SEC could not quantify a benefit, correct?
Yes, sir. I think there's a difference between quantify and find, but,
Okay.
but certainly a lot of what we do is very difficult to quantify, even though it's very important.
And so so in the decision-making process of which regulations you'll go forward to, why was this one done when other areas when you can quantify a benefit?
DERA responds to the rules as they come up, as they're treated by the commission. We try to explain and clarify to them what the economic facets of the decision are, and then they are free to weigh those benefits and costs against the other considerations.
Was it fair to say that this was done because it was a mandate of Congress as opposed to the SEC recommending that it be done?
I believe it was a mandate of Congress. I believe it was in Dodd-Frank. Yes, sir.
And so it's a shell situation as opposed to a may situation. But of course, there was no time limit on this. So within a whole gamut of things that the SEC could be working on, there were other areas where you could quantify a benefit. And this, correct?
Where we can probably do more quantification than in that case, yes.
Right. So is there a reason why we see in areas where you can't quantify, the SEC goes ahead and does so, and where you can't quantify, vice versa?
We are in many ways a reactive division in the sense that we're asked to weigh in on a rule that is to be considered. We don't actually control when the rules are considered.
But do you make recommendations at the end of your report?
About the order of consideration?
Yes.
No, sir, we don't.
Okay. Unfortunately, my time is already up. The gentlelady from New York is recognized for 5 minutes.
Thank you, Mr. Chairman. Dr. Flannery, it's very good to see you again. And as you know, I'm a big fan of structured data, especially the use of XBRL. It certainly makes it easier for investors to locate good investments, diamonds in the rough, and easier for startups and new businesses, if they have a good story, to get it out and let investors know where they can make a good investment. And in your testimony, you described DERA as the hub of information within the Commission. And so can you talk a little bit about why structured data like XBRL is useful to the investor and useful to the SEC, and exactly where does the implementation of it stand now with the SEC?
Yes. We have an Office of Structured Disclosure inside of DERA, and the purpose of that office is to advise where and what and how data should be structured. So when there's a new rule, when there's a revised form, these folks evaluate what can be captured and what's the best technical way for it to be captured, of which XBRL is one good possibility. A good example of what that does for us, the XBRL, is we now publish on our website quarterly financial reports for all registrants. So we have about 8,000 registrants, and the small ones don't get a lot of attention from the commercial data services, the commercial data providers. So we have a complete set of information, and that's useful to investors for the purposes you said. It's useful for us when we do a rule or when we do a risk analysis, because we have a more complete and a much better grasp of the information that is most relevant to the firms that have the hardest time raising capital. So it's a very valuable resource for us, and we provided the data to the public. One of the things about XBRL is that the data are to be filed by the end of the quarter, and usually within the next week, we have those data sets up and available for people to use.
Well, some people say they don't use it because there's no enforcement on the accuracy of the XBRL. And aren't you dependent on what the industry hands you? The company hands you their data. You don't check to make sure that data is correct. Is that correct?
Well, there are various internal consistency checks that can be done pretty easily with an XBRL taxonomy.
But you do rely on the industry giving you the information,
yes,
correct?
we do. Yes, we do. And there have been there's been a learning process since 2009 when we first required the largest registrants to report using XBRL.
How could you enforce the accuracy more? That is the one complaint that I hear from investors, that they would like it to be accurate, and there's no guarantee that it's accurate. So they say they don't use it because there's no really check on the accuracy. How could we improve the accuracy and the enforcement of accuracy on the data you receive?
That's a primary objective of our Office of Structured Disclosure. And as I mentioned, within XBRL, there are various mechanisms for at least assuring the internal consistency of the data. Now, if somebody files an incorrect number, whether that's an XBRL or it's on paper, there's nothing we can do about that as long as it is not inconsistent with other parts of the report. But our OSD people, Office of Structured Disclosure, are investigating at all times. When I said how the data get reported, they're investigating how we can most parsimoniously and efficiently assure or increase compliance.
They say that one of the best ways to get accurate data is, when the sale takes place on the exchange, just being able to capture that as opposed to depending on private industry. What's your response to that?
That would be a stock sale.
Yeah.
Yes, and the data I've been thinking about, I thought you were talking about, was the financials provided by registrants in XBRL, and so that wouldn't be in the same venue.
Yeah, but the stock sales.
Yeah, the stock sales, we have direct feeds, and of course there are direct feeds that go to various private participants, but we have direct feeds, and the CAT, Consolidated Audit Trail, which is to be considered by the Commission next Wednesday, I believe, will eventually make those audit trails extremely accurate and extremely detailed.
Now, how does your work differ from the Office of Financial Research, which is also capturing this information? Do you share your information with them, or?
Yes, we absolutely do. The Office of Financial Research is of course, the responsible to the FSOC, and we have collaborated with them on a couple of important data sets. One is Form PF, which is hedge fund data, very confidential data, but very valuable data. The other is money market mutual fund data. They've been involved in helping us design taxonomies, and we look forward to continuing a fruitful relation with them.
I thank you. The gentlelady's time has expired. We're going to be coming up on votes. I'm going to try to keep things within it time, so. I was recognized.
Thank you, Mr. Chairman. Mr. Flannery, I had some questions for you. As you know, the President signed Executive Order 13579 that required all agencies to perform an analysis of rules that may be outmoded, ineffective, insufficient, or excessively burdensome, and to modify, streamline, expand, or repeal them in accordance with that which has been learned. Seems like to me your division is uniquely qualified to perform research for the SEC, and that's the purpose of your division, correct?
It's certainly one of the purposes, yes.
Have you all participated? Has your division participated in any of these retrospective reviews? So to speak?
We are committed under the Regulatory Flexibility Act to examine existing rules, as you know. They usually get examined after about 10 years after their instance. And we do that in conjunction with the General Counsel's office. I think rather than taking credit for finding potential things that can be improved in these rules, I should share it with some of the other divisions, because a lot of information comes into the other divisions from the industry, either in the form of inquiries or complaints. And there are frequently things that can be, where the burden can be reduced by staff guidelines, by no action letters, and a lot of the kinks, if you will, that might be in an initial rule can be worked out that way by staff interaction with the registrants.
Well, but since the President signed this order, can you think of any example in which a rule has been repealed, such as it is, because it was excessively burdensome, ineffective, or outmoded?
Well, I can give you an example of a proposed rule in the mutual fund space that is based on a need for better information and a reduction in the frequency of reporting, and that would have to do with what we call NPORT, which is the mutual fund asset composition reports that are going to be filed if the rule is improved. So we were trying to take advantage of better information, tagging the data, and we were trying to reduce the burdensomeness of the.
And that was done through staff guidelines?
Yes.
Guidelines?
Yes.
But again, just to be clear, modify, streamline, expand, or repeal. There's not an instance that you can think of where a rule has been repealed based on this analysis that's taken place in the agency?
I cannot remember one, no, sir.
All right. Another question that I have deals with this the issue of regulations that are developed, some pursuant to Dodd-Frank, with participation from joint participation from individual agencies. And obviously, there is a requirement of review by your office in terms of cost-benefit analysis, the economic impact, the economic effects of these rules. But there are some who suggest that when it is a joint rulemaking, that cost-benefit analysis is not required. What's your take on that? And have you all had pushback from the other agencies that you've had to develop rules with on that specific issue? How do you deal with that?
Yeah, of course, you're right. We have a securities law requirement that we consider, among other things, efficiency, competition, and capital formation, which is unique to the SEC. So there are instances where we will do a joint rule, most often with the banking regulators, and ours will be the only economic analysis. There's one that we're involved in now where we...
So is the analysis that you do, is that used in the promulgation of the rule in the process?
Yes, we do an analysis as it affects our registrants, because of course the rule that we promulgate affects only...
So the banking regulators don't do that?
I believe that's correct. They're not required. I don't know what they do inside, but they're not required to put an economic analysis out with the rule text for public comment.
And does that, do you see a problem there where you have an extensive work done by your agency evaluating the costs and benefits on your side as it relates to your registrants, but not as it relates to those who are regulated by the other agency? Is that a problem?
I don't know whether there's a problem in that regard. What I know is that we have different statutory and regulatory constraints that we operate under. We've developed our guidance on economic analysis to take advantage of our specific expertise and to take advantage and to fit with the specific institutions and parts of the capital markets we work with. Okay. Whether that should transplant elsewhere is beyond my expertise.
Thank you. My time has expired.
Thank you, Mr. Hunt. Also recognized for 5 minutes.
Thank you, Mr. Chairman. My first statement is to thank you and to thank our distinguished panel of witnesses for their appearance and testimony today. My first question is to Mark Flannery. Mr. Flannery, as you're aware, the Department of Labor issued a rule earlier this month regarding the fiduciary standard of care that is owed to investors when providing them personalized investment advice about their retirement accounts. This standard of care ensures that financial advisors providing advice act in the client's best interest. Chairman White has publicly stated that she would like the SEC to implement its own fiduciary duty rule. My question to you is, has the SEC studied whether conflicts of interest in the provision of investment advice hurts investors?
As you say, this is a major objective of the chair, and she has people in trading and markets who oversee brokers and dealers. She has people in IM, investment management, who oversee registered investment advisors, and staff from DERA collaborating on developing a rule. Turns out, for reasons that surprised me very much because I was new to the SEC, it turned out to be that it is a very difficult problem. It's taking a long time to get it right, and we want to make sure that we get it right when we get something out.
This committee has considered bills that would impose a cost-benefit analysis on the SEC, and I believe these bills would favor industry over investors and open the SEC up to increased litigation risks. Can you please describe all of the economic analysis obligations that the SEC undertakes when it looks to propose a new rule or an amendment to an existing rule?
Yes, we have, as I said, we have a 15 or 20-page document that we refer to as the guidance, which is about 4 years old and lays out the content of what should go into an economic analysis at the SEC. The first thing we do is we establish what's called a baseline. We try to document what is the state of the market, what is the state of the affected players if we don't introduce the rule. So we start with a baseline, we spend a lot of time trying to document that with statistics, and that gives everybody involved in the discussion an opportunity or perhaps an obligation to work off of the same baseline. Then we are interested in identifying who will be affected by the rule, who is likely to be affected by the rule, and what would be the benefits and costs to the various people who are affected, the various firms and individuals. One of the things that we find is that there are many cases where we cannot quantify a benefit. So I would love someone to explain to me how, for example, I could quantify the benefit of a more informed investor. I know it's positive, but I don't know how big it is compared to
I can't
the
answer
dollar.
your question, but I am very much in favor of that rule that the Secretary of Labor has recommended and has had hearings for a long time, and that I think would certainly help investors. My next question is to Mark Wyatt. Mr. Wyatt, the Office of Compliance Inspection and Examinations completed approximately 2,000 examinations by 11 regional offices. Is the current SEC budget sufficient to keep pace with the increasing number of examinations that need to be conducted?
We certainly are trying to use our limited resources as effectively as possible. We are trying to endeavor to increase our examinations. For last year, fiscal year 2015 was a 4-year high for the examinations. That said, we are striving to conduct additional examinations and increase our coverage in the investment advisor space, which currently is around 10%. On the broker-dealer side, together with FINRA, we get to roughly 50% of those registrants. So we certainly welcome additional resources and information that can help us develop our exam program and our risk-based program to conduct further exams.
How do the SEC's resources to examine registrants compare to the resources of some of the large broker-dealers, banks, or other public companies that the SEC is supposed to hold accountable?
And very quickly.
The SEC has, OC has 1,011 examiners. There are some large global registrants who have over 3,000 alone in their compliance program, for a global compliance program, I will highlight.
Thank you. I yield back.
Mr. Royce?
Well, thank you, Mr. Chairman. Thank you to the witnesses for joining us today. Experts have deemed the United Kingdom's retail distribution review as being effectively identical to the Labor Department's rule. In the eyes of not just industry, but the British government itself, implementation of that RDR review created what they called an advice gap that locked out middle and lower income savers from investment advice. And I've studied the Johnson report about the Department of Labor's communications with the SEC during the lead up to the rule's release. I share the Senator's frustration with the Department's lack of cooperation in releasing all of its communication with the Commission regarding its rule. So I'm just going to ask Mr. Flannery, did the DOL and the SEC communicate about the impact of Great Britain's RDR on British consumers, and if so, to what extent? And if not, why did the SEC not think it relevant to reference the fact that a developed economy has already implemented a rule similar to the DOL's rule, and this was no longer a hypothetical situation?
The retail distribution review, which I think took effect at the beginning of 2013, we viewed in the SEC, we viewed that as an extraordinarily interesting policy step. We could call it an experiment because it didn't involve us. I undertook a couple of conference calls with people over in the regulatory agencies there. With me on those conference calls was one of my staff who was involved in dealing with the Department of Labor economists. So we conveyed certainly that information to them. I don't know in what form. I'm not familiar with the details, but certainly the information was conveyed through that individual.
But information coming back the other way about the advice gap that they were experiencing
in Britain with middle income and lower income savers from investment advice. That information was being collected or studied?
Well, it was certainly conveyed to the Department of Labor. When we are asked to provide technical advice to any organization, we provide technical advice based on our expertise with our institutions and our space. So if we send over comments or suggestions, those people are operating in a different regulatory environment under different legislation, and it's therefore their decision which of our comments is most appropriate to their situation.
I was going to ask Mr. McKessie a question, and this goes to the issue of the office's creation under an amendment I offered in this committee. It came as a result, actually, of Harry Markopoulos's struggle, which he explained to us, his decade-long travail to bring Bernie Madoff's Ponzi scheme to the attention of the SEC, and in particular, his frustration year after year after year, the failure of the SEC to take any action against Bernie Madoff. So the idea, in a nutshell, was that by establishing a separate office within the Commission, the SEC would be better situated to protect whistleblowers and ensure that their concerns are, in fact, acted on and not handled as that previous situation was. Do you think the new structure is working, and what could be done to improve it? And I'm also concerned that, not unlike the gaps in coordination we had between regional offices and divisions in the SEC before your office was created, there may be gaps in coordination with other parts of the government. How does your office coordinate with other federal agencies that allege conduct that is beyond the SEC's jurisdiction? That is the thrust of what I'm concerned about.
So I think the creation of the Office of the Whistleblower, by the way, I'm very grateful for it because it created my job. I think it has been effective in encouraging whistleblowers to come forward. I certainly have had a number of meetings now with Mr. Markopoulos and gathered his thoughts on how we can be as effective in advocating for whistleblowers. I think beyond the Office of the Whistleblower, there are other structural changes in the agency that I think have been effective in dealing with issues like information gaps, the creation of the Office of Market Intelligence, which is a centralized office that centralizes all the intelligence that comes into the agency to make sure that when we get a tip from a whistleblower, if it's related to something that somebody's already looking at, that it finds the right home and that we don't have competing offices working on the same matter. So I think, and at the end of the day, I think the fact that the whistleblower office provides three benefits to whistleblowers: confidentiality, anti-retaliation protections, and the ability to be paid, has created real incentives to allow people to come forward if they otherwise were unwilling to or reluctant to. And I think we're seeing the results of that in the fact that we've solicited over 16,000 tips since the program went into effect.
Good, good. Well, thanks again, Chairman Garrett. Thank you.
Gentleman from Massachusetts, 5 minutes recognized.
Good morning. Thank you, Mr. Chairman. I want to thank the witnesses for their help on this issue. Mr. Butler, I was a member of this committee during the financial crisis going back to 2008, and I think it is beyond any reasonable doubt that the rating agencies played an important role as a facilitator of that crisis, and they not only amplified the intensity of the crisis, but also, I think, facilitated the wider scope of that crisis as well. And, you know, independent researchers and investigators, as well as the Justice Department, have basically said that the sort of pay-to-play role that, or system that's been in place where customers pay for ratings, and that the conflict of interests on the part of the rating agencies contributed greatly to the problems we had back then, and that model has to change. Now, since the crisis, your agency hasn't instituted any fundamental changes in the credit agency business model that created those conflicts of interest, and credit rating agencies have returned to record profits. Your own most recent examinations of found severe failures by major credit agencies to comply with their own stated policies and procedures, yet you have not levied any fines or penalties on rating agencies. You've not used your statutory authority under Section 15E of the Security Exchange Act to suspend agencies or individuals from ratings, and the Office of Credit Ratings Public Examination do not even identify. They don't even identify the specific rating agencies that violate procedural rules. You don't even call them out. No name and shame. It seems to me that the system is designed really to shield the rating agencies from any accountability. We don't even identify the people. We use terms like one of the larger rating agencies, which I assume is one of the big three. Your testimony states that the OCR attempts to serve the public interest and protect users of credit ratings. But I got to ask you, do you really believe that we can get to that place without eliminating the conflict of interest that currently exists where companies pay the rating agencies for favorable credit ratings, and that the companies are in competition with each other? There's a great segment in The Big Short, that movie, where they're talking to one of the folks from Standard & Poor's, and the analyst asks, why aren't you tougher on or more demanding in these guidelines? And the woman from Standard & Poor's says, well, if we do, they'll just go to Moody's. And that sort of encapsulates the problem here. So what's the answer here? I mean, as long as we have that conflict of interest, are we ever going to get to a place where we're actually, as your mission states, are we going to be able to protect the users of credit ratings?
In my estimation, compliance is not a destination, but it's a journey. And we're well along on that journey with regard to the rating agencies and in infusing in them the importance of compliance, enhanced governance, training, transparency, training, and other methods to build rigor within the rating process and to establish integrity. To address specifically your question with regard to the issuer pays conflict, in August 2014, the Commission adopted a new set of rules, and the rules were effective fully in June of 2015. Importantly, within that set of rules, there is a requirement for a complete separation of the sales and marketing function from the analytical function. And that's accomplished by prohibiting rating analysts or developers of methodology from participating in sales and marketing activities, or from being influenced by other business considerations. And apart from the prohibition...
Let me just stop you there, because I've only got 30 seconds left. Your report says that they're departing from their own policies and that they're not following their own programs, that and those companies are not being held accountable under your system, the one you've got right now. So, and that's after this last iteration of changes has come forward. They're still paying for ratings. They're still paying for ratings. They know, the rating agencies know where their deal flow comes from, and they're acting accordingly. I don't see any changes here compared to what we were doing before.
And I thank the gentleman for his questions, and I'd ask everybody not to end with a question, since we're trying to get in before the vote's called. Who's up? Mr. Hill, recognized for 5 minutes.
Thanks, Mr. Chairman. Thank you for the panel. Thanks for your service at the Commission. Dr. Flannery, I took a question you answered a few minutes ago about the DOL rule and your work and the Chair's commitment to a fiduciary rule at the Commission. The SEC's got 80 years of experience in overseeing broker-dealers and investment managers and doing economic analysis on that, and you made the statement that it's really, really hard to get it right. And obviously this has been something that the Commission was asked to study back in 2010 as a part of Dodd-Frank. And yet the Department of Labor has rushed into this rule, not rushed, that's not fair to the DOL because they've worked on it for 2 or 3 years. But my biggest complaint about the fiduciary rule is that it wasn't done in conjunction with the Commission, and the Commission didn't take the lead on it to get it right on behalf of all market participants. Since it is hard, what do you think are the hardest things about it when you look at it from an economic analytic point of view of trying to, quote, get it right? I mean, obviously, FINRA and the SEC have led the way in designing suitability standards and best interest standards. And if we manage money on a discretionary basis, it's subject to a fiduciary standard in the industry. So what do you rank as the most difficult challenges there? Well, you can answer that question because you're not commenting on the Department of Labor, I think.
No, in the context of the SEC and in the context of combining the standards to which the fiduciary standards to which broker-dealers and investment advisors have been held historically, they are different standards. And in the old days, broker-dealers sold things to people and got compensated via commission. Investment advisors gave advice, didn't get compensated via commissions, but got compensated via fees. Now the broker-dealers have moved into the advice-giving space, and they bring with them, however, a compensation arrangement that was designed and that survived in a somewhat different environment. So one of the first questions that comes up here is, what does it mean to give financial advice? If I'm a broker, I've got to make sure that the security is suitable for my customer, but after the customer has bought the security, I don't have any further responsibility to monitor the customer's portfolio.
Well, that's not true, is it? I mean, they've got an obligation to make sure that the financial disclosure and their situation is reviewed at least annually in most firms' policy manuals for net worth, earnings, suitability, changing circumstances, marriage, having children, having an estate plan. I mean, they do have a continuing obligation to their client, don't they, under all policies of FINRA and the SEC?
I believe that the broker-dealer has an obligation that is transactions-oriented as opposed to life change. So if there's a life change and the customer comes back, there could be a different definition of suitability. But if there's a life change and the customer doesn't come back, there's no responsibility, as I understand it, for a broker to call up and say, hey, now that you're remarried, you ought to do something different.
Well, we don't have to debate that here. I would very much disagree with that based on looking at firms' policies and procedures manuals for a couple of decades. But what else do you think is challenging about getting it right from the Commission's point of view?
One of the things that's surprising to me is how difficult it is to disclose information effectively. And the broker-dealer and the investment advisor rules and standards are based on disclosure. And there's sometimes a difference between disclosure and the transmission of information. So we've in DERA just started a small behavioral finance unit to try to understand how people process information that is maybe second nature to those in the finance industry, but new and confusing to those outside.
Couldn't the Department of Labor's approach, though, of creating, one set of approaches for a retirement account versus another set of approaches executed by the SEC and FINRA on behalf of all other account categories lead to investor confusion?
I suppose it could. Certainly, there's some inevitable confusion, I suppose, because the Department of Labor rules are promulgated under a different set of statutes, different set of considerations than the securities laws under which we operate.
And hence, that's why I really think that in an ideal circumstance, OMB, the administration, would have insisted that the Commission take the leadership role in harmonizing this approach. Thank you, Mr. Chairman. I yield back.
Thank you. The gentleman yields back. Gentleman from Connecticut is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, gentlemen, for being with us today and for your good work. I have two questions which I recognize are a little tangential to your offices and divisions, but both pertain to topics in which I've been concerned about what I perceive as silence on the part of the SEC, so I'm hoping I can get at least some provisional feedback on these two topics. The first pertains to insider trading. As you all know, the Second Circuit on the Newman decision, apart from overturning two very high-profile insider trading convictions, put a great deal of uncertainty into future prosecutions of insider trading. I think we could all agree on two things. Number one, we now don't have a good definition of insider trading, and I, for one, am a believer that if we're going to send people to jail, we should have pretty good statutory definitions for why we're sending them to jail. Secondly, without getting into the guts of Newman, as you know, the decision really was around whether a tippee can be held liable unless the tippee knows of the personal benefit received by the tipper in exchange for the disclosure. So if I'm a corporate insider and I tell you, hey, I shouldn't be telling you this, it's probably illegal, but you could make a lot of money, and you trade on it, so long as you don't know that I've received some tangible personal benefit, you are not prosecutable. You are not liable under the Newman decision. So I'm looking for, I guess, a little bit more clarity from the SEC about whether there should, in fact, be a statutory definition of insider trading. I point out that my colleague, Mr. Lynch, I have also put forward some legislation. Two senators, Menendez and Reed, have put forward legislation. But I'm looking, I guess, for a little bit more guidance from the SEC about whether the uncertainty introduced by Newman is, in fact, a problem that we should address.
I believe, as the only member of the Enforcement Division, I'm probably the best qualified to talk about this. But that all said, I think the Newman decision raises issues that are extraordinarily nuanced, and I think I want to be as helpful as I can, but I think to get a real appreciation for the considerations that go into how Newman affects our Enforcement Division and our ability to bring insider trading cases is best addressed by someone who has more background in that. And of course, I'd be happy to take any questions back and have the right person get back to you. Obviously, we're very well aware of the Newman decision and the nuances of it. But I think you probably would be better served by hearing from people who more appreciate the nuances of how it impacts our enforcement efforts.
Yeah, no, I appreciate that. I recognize that this isn't exactly the panel that's right on point for that. But I'm sensing a certain amount, and I understand this. We've got a vast body of case law associated with insider trading. We've got a lot of ambiguity that stems from no direct statutory definition of insider trading. I would really appreciate it if the Commission would, in fact, focus on nuance and getting us a more clear message, and maybe try to get away a little bit from what is bureaucratic or what is case law tradition, and maybe a little bit of bureaucratic inertia. Because again, under the example that I gave on the question of tipper to tippee liability, at some level, yes, it's nuanced, but at some level, it's also kind of commonsensical. Second question. We've been doing a lot of work on the Jobs Act, which I supported, and now we're sort of looking at a bunch of additional changes, expansions to the Job Act. And the whole idea of the Job Act, of course, is that young companies shouldn't bear the full burden of Sarbanes-Oxley compliance. I've had estimates anywhere between $1 and $2 million a year for the cost of Sarbanes-Oxley compliance, so we're spending a ton of time on that issue. I think that's good. But I can't seem to get enough attention drawn to the odd fact that one of the biggest sources of cost for young companies going public is a remarkably consistent gross spread of 7%. Let's just say that the average IPO is in the neighborhood of $200 million, 7%. That means $14 million in the IPO out the door. And we're spending a ton of time on that $1 or $2 million a year associated with Sarbanes-Oxley compliance. But I'm having trouble sort of really understanding why we're not focused more on the odd fact that 95% of all IPOs that have occurred, at least in the 10-year period after 98 to 2007 in the United States, 95% had a 7% growth spread. Exactly. In Europe, there's no such clustering. And in fact, in Europe, IPOs growth spread average about 4%, and you almost never see a growth spread as high as 1%. Does that clustering at 7% over such a persistent period of time strike you as odd and perhaps worthy of investigation?
Let me try that. Another industry which is not nearly so germane to the issues you express, but another industry that has the same phenomenon is real estate brokers, where I believe there the number is more likely to be 6%. That's always puzzled me. There are some economic analyses for both of these cases about why this might actually be a good contract. But it's, you can also find arguments that are equivalent to what's implicit in your comment, that maybe there's something nefarious going on. So you can find economic arguments on both sides.
Thank you. Thank you for the question.
Thank you. I yield back. Thank you, Mr. Chairman.
Mr. Holmgren?
Thank you, Mr. Chairman. Thank you all so much for being here. I appreciate your work and your testimony today. Mr. Wyatt, Harry Markopoulos, who initially warned the SEC about Bernie Madoff's Ponzi scheme, recently revealed that he is working to uncover 3 multi-billion-dollar schemes, including one that will be bigger than Madoff's. As you know, many of the failures that allowed Bernie Madoff to continue his Ponzi scheme for as long as he did can be traced to the failures of OC examinations to connect the very apparent dots. Multiple SEC offices, including OC, were unaware of parallel investigations into Madoff's entities. Do you believe the institutional changes implemented by OC since 2009 are sufficient to stop future fraud? And if not, what else needs to be done?
I do believe that the changes that we made after Madoff have significantly enhanced our ability to detect those types of activities. The streamlining of our TCR program to ensure that there are no silos in the regions, as well as the connectivity that we have amongst the regions to ensure if we see a theme or a risk throughout, we can act on it accordingly and bring the resources to bear. So we're continuing to run a risk-based program. Part of evaluating our risks are continuing to look for any emerging risks and connecting the dots, as you say, with the TCR program and other areas, including information gathered from other divisions such as DERA.
Okay. Mr. White, the SEC did not and still does not have a standardized identification code that consistently identifies all the entities it regulates and makes connections between them. I believe the Madoff failure was in part a data standards failure. Last year, Congressman Issa, myself, and a number of other members of this committee introduced legislation called the Financial Transparency Act to direct all financial regulators, including the SEC, to adopt data standards for information they collect with the hope of transforming the current landscape of disconnected documents into open, searchable data. In fact, the original name of the bill was the Madoff Transparency Act. This means, for instance, that the SEC would adopt the legal entity identifier to consistently identify all the entities it regulates and affiliations between them. So in the future, parallel investigations into related entities like Madoff's will be electronically visible. For all information required by other laws to be made public, the bill directs each agency to publish such information as open data, machine-readable, and freely downloadable. Won't an open data initiative like this help prevent future failures like we saw with the Bernie Madoff scheme?
Well, we certainly have adopted strategies to enhance our use of data analytics and to capture all the data that's available to us, as I mentioned, from internal and external sources. We've also centralized all the information we have with regarding examinations, so anyone throughout OC can go in, look at a given registrant, see what activities have been involved in an examination or even a non-exam review for that registrant. So we're certainly applying the data analytics and would welcome anything that could give us additional insight into the activities of the registrants that we're examining.
Thanks. Well, I believe we have to do better. We can do better, and there's with incredible technologies and connectivity, we ought to be able to recognize this a lot sooner. Let me switch to Mr. Flannery, if I could. The Department of Labor's proposed fiduciary rule, which was recently finalized, mentions annuities 172 times, but the regulatory impact analysis does not examine the impact of the rule on annuities, advisors, insurers, or the retirement savers using them. Last October, David Grimm from the SEC's Division of Investment Management testified, and I quote, he said, "A lot of what we've been talking about with them, the Department of Labor, has been on impacts. You know, the impacts of choices that they are making on investors." What impacts is Mr. Grimm describing, and did your office conduct any cost-benefit analysis?
We did not directly do a cost-benefit analysis. We are involved in advising and providing comments, technical comments. And I'm sorry, I'm not familiar with what Mr. Grimm was.
Thank you, gentlemen's time has expired.
Expired. Yield back.
We're getting ready to vote. The chair now recognizes Mr. Foster for a period of 5 minutes.
Thank you, Mr. Chairman. And my questions, I guess, will be directed to Mr. Flannery. I'd like to, first and foremost, congratulate you on your hiring of 2 physics PhDs. As the only physicist in Congress, in fact, the only PhD scientist of any kind, I recognize the complexities of things like structured financial products, the technology that's involved in high-frequency trading. All these are the sort of things where you need that kind of expertise, and I'm very glad to see that you're recognizing that too.
Thank you.
I'm also the author of the contingent capital requirements in the Dodd-Frank bill, and as someone who's widely credited with having invented the concept back, I guess, in 2002, and then now we've seen it adopted really worldwide, I think, with what I see as a lot of success. You've seen, for example, the Swiss banking regulators, which are faced with the problem that their economy is not big enough to backstop the size banks that they have. They have used contingent capital to make those viewed as very solid counterparties, even in contemplated times of financial stress. We've seen the whole Deutsche Bank ongoing saga, where Deutsche Bank is aggressively restructuring, deleveraging, cutting bonuses and so on, because driven in large part by the worries that the contingent convertible coupons will not be paid more than a year away. So it is, to my mind, working very successfully at providing the early warning signal that is one of their main merits. And then finally, I guess most recently, Canada, the new government in Canada announcing that they are going to use contingent capital instruments to make sure the Canadian taxpayer is not on the hook if their big banks get in trouble. So I think, I view this as a very successful thing, and I've continued to try to get them adopted, which they have full regulatory authority, but we're not seeing very aggressive adoption. So I was wondering if you could just give your take on what you see as the lessons learned in their worldwide thing, and the way forward for potentially getting those lessons used in the United States.
Well, first of all, it's a pleasure to meet you. Contingent capital is something that personally and in my academic environment, my academic career, I spent a fair amount of time talking about. I think you put your finger on what I view to be the biggest advantage of contingent capital instruments, and that is that rather than wait until the last minute when a firm is close to insolvency, contingent capital instruments address that possibility, keep us away from that possibility, and give the managers and the shareholders of the firm an incentive to stay away from certain trigger points. When I first started talking about this, the crisis was fresh in our minds, and people had this vision that capital would be almost zero, then there'd be a conversion. But by the time capital is almost zero, all sorts of bad things have started to happen to these firms. I believe, I'm sure you're correct when you say that they could be permitted as part of the capital stack in the United States. They haven't been, and I think there are people who feel that higher capital, formal equity requirements are safer, more protective than contingent capital requirements are. And then how one comes out on that is based on what one believes is the effect of higher capital requirements on the operation of the firm and the pricing of its products.
Do you think at this point there are good examples of trigger mechanisms that have proven workable in times of stress, or is that still an ongoing experiment?
I believe that's a problem. The securities in Europe and Asia that have been so successful have book value trigger mechanisms. And one of the characteristics of firms that get into trouble is that their market value deteriorates much more quickly than their book value does. In other words, the market loses confidence in the firm despite the fact that it may be showing strong book capital relations. And so the triggering of these COCOs, contingent capital instruments, off of book capital ratios, I view as sort of problematic and likely to interfere with their value.
And are there issues just related to the SEC, how they'd be registered under the 1933 Act, or are those, if you go and go to the European websites with the thought of investing in contingent capitals, there's this big warning, is if you're a U.S. citizen, forget it. And I was just wondering if, if there is a clear regulatory path, or whether you'd see SEC issues involved in making these widely used.
I'm not aware of any considerations actively going on inside the SEC, but it would focus on disclosure of the risks so that investors could understand what was likely to happen and accept the risks for the compensation they're being given.
Thank you. The gentleman's time has expired. Mr. Duffy.
Thank you, Mr. Chairman. Welcome, panel. Great to have you here. I'm just a warm-up act for Ms. Wagner, who's going to go in a second on the DOL fiduciary. Obviously, many of us, as you're well aware, have concerns about the rule. And it's my understanding that the SEC also shared some concerns about the proposed rule and now the actual rule. Mr. Flannery, is it fair to say that the Department of Labor, for the most part, disregarded much of the advice that the SEC gave to them in regard to this rule?
The advice that was given, I think of it more as technical comments. Some of it was incorporated into the final rule and some was not. I don't know about the preponderance.
Okay. I mean, one of our concerns, for example, would be, that one of your economists suggested that the Department of Labor should measure improper activity of advisors through measuring conflict of interest. The proposed or the purpose of the rulemaking process, not projected investment returns, and it seems like the DOL didn't take that advice. Is that fair to say?
I'm not familiar with the final DOL rule. It's 395 pages, and I look forward to reading it, but I haven't yet.
Have you undertaken any analysis of the impact of this rule on investors?
We have not yet gotten to that point because our internal deliberations, again in a different security space, have not gotten to the point of generating a rule. So we have not yet done that sort of economic analysis.
Tell me if you share my concern, because I come from central, western, and northern Wisconsin. Not a really wealthy part of the world. We don't have a lot of people who have $500,000 or $750,000 in their retirement accounts. We have people who have $30,000 and $50,000 and $80,000 in their retirement accounts. There's some concern that we're going to migrate those folks from getting advice from someone that they've worked with and that they know, that they trust, to a different computer model, the robo-advisor. Do you foresee that happening as well?
Well, I think you can look at the robo-advisor in the way you have. You can also look at it as an opportunity for people who are just getting into retirement savings, people who are generally more comfortable taking advice from computers than I might be or you might be.
So let's actually play that out a little bit, because it might not be just the person who just started to invest. Now, the first-time investor in Washington, D.C. might start after a couple years and have $80,000 in their retirement account. But in my community, it's after 25 years they have $80,000 in their account. And is based on, and maybe this is open to the panel, do you think that maybe someone who's not an expert in investing, their life focus has been elsewhere, but they've been responsible, they put a little bit of money away. Do you think that, say, look back to last August, that person, when the markets start to move, is going to be more compelled to look at their computer screen and make the right choice, as opposed to calling their investment advisor and trying to sell their investments, and their advisor is going to go, well, hold on a second, whoa. That's not the right call right now. We should actually ride this storm. That's not part of our plan. We know there's peaks, we know there's valleys, we ride it out, don't sell. Are they going to get the same advice from the computer? And I guess my question is, aren't they going to make really bad choices for their future if you have a robo-advisor as opposed to a financial advisor?
I suspect that there were a lot of people in the world, in Wisconsin, who didn't even know what was happening that day, didn't look at their financial statements. But in general, I agree with you entirely that good financial advice is valuable. I think that good financial advice also sometimes comes with conflicts. And
I don't dispute that, but does good financial advice come from a computer?
I don't know enough about those computers, so I can't tell you.
If I'm able to get 8 or 10 questions about some of my goals, some of my income, how many kids I have, what I want in retirement, I put it in and it hits an algorithm and it spits out some advice. Do you think that just because I'm a low income individual, I'm a low dollar saver, that I shouldn't be entitled to the advice that comes from someone who makes $800,000 a year?
I guess we don't know. Certainly the point you make is widely discussed, but we don't know for a fact what's going to happen.
So do you have a study in the works so we can know?
We will know when we take up a rule at the SEC. We will.
And isn't it too late? Isn't it too late? Because my people are already going to be kicked out of personal advice, and they're going to be relegated to their computer. Do you share that concern? They're already out once you do your study, and the rule's implemented.
Again, the rules under which the DOL operate are different from those, and the legislative authorities are different from those.
I can't wait to see how we navigate both an SEC and a DOL rule, and how that's going to play out on the expense side, and how we're going to get more people than I know. Sorry, Mr. Chairman, I yield back.
Gentleman from California.
Thank you. I would point out that I think it was Congress's intention that the SEC and the Department of Labor have very similar or identical rules. It is absurd to think that IRA accounts would have one set of protections and non-IRA, pension accounts would have another. And it's even more absurd to say that the IRA accounts, typically controlled by those in their 50s and 60s, should have more protection than widows and widowers and elderly people who are typically in middle-class families control the larger accounts. So I share some of the last gentleman's concerns. Mr. Chairman, the one part of the SEC we don't have before us are those concerned with accounting standards. I'd like to enter into the record my letter of earlier this month demonstrating the incredible harm that is being done to our economy by the departure from accepted accounting theory that requires companies to write off their research and experimentation costs. Thank you. Mr. Butler, we're still suffering from this 2008 downturn. I think it was mostly caused by the credit rating agencies. We still have a system where the umpire is paid by one of the teams and selected by that team. And the SEC has decided to, instead of being an agency that favors transparency for investors, has decided to conceal this by such relatively meaningless so-called protections. It says, well, the sales force can't talk to those who do the ratings. The people who do the ratings are compensated by the company. Their promotions depend upon the company. They want the company to be successful. Is there any rule that those engaged in rating debt obligations cannot receive stock options, bonuses, or any benefit from the success of the company they work for? Mr. Butler.
Each of the companies has different compensations arrangements.
I asked, is there any SEC prohibition?
With regards specifically to rating analysts and compensation?
Yeah.
I'd have to take that back.
Okay, so if you give great inflation, the company makes money, your stock options do better, and the SEC has no rule of which you're aware. And if you're not aware of the rule, it'd be very hard to think the rule's being enforced, since you're the one that would be enforcing the rule. The debt markets are obviously far more important to the economy, or at least involve far more capital than the stock markets. Those who invest are basically entirely dependent upon the ratings. Even if you know better, you're managing, say, the T. Rowe Price bond fund. If you decide to forego buying a AA rated bond that pays 20 basis points more, then I'm going to invest in Vanguard, because all I'm going to be able to do as an investor is decide which has the highest rating and the highest yield. I want to talk about one particular problem, that is the Peruvian agrarian reform bonds. Obviously, the way to make money is to try to get Peru as a client. It's a significant country, and one way to do that is to avoid even offering to rate these agrarian bonds that seem to be a part of a selective default. Is there any rule that says that a credit rating agency can't refuse to rate bonds because they can make more money from the issue, they're paid off one way or another not to rate them?
I'm generally familiar with the media coverage on the Peruvian bonds, and I can't obviously discuss the specifics of a particular
Is there
bond
any rule that says that you enforce that would prohibit Peru from saying, please don't comment on our agrarian bonds, and we'll make sure to give you a contract worth millions of dollars in some other part of our financial dealings? Is there any rule that you can point to that prohibits that?
The rules provide specifically for an absolute prohibition a rating analyst to be involved in sales and
I
marketing
didn't, that's not
activities.
read, this is whether you take the engagement. Doesn't involve the rating analyst, involves the sales force.
The rule prohibits rating, the analytical function from being involved in the sales and marketing function. That's achieved by prohibiting analysts from being involved in sales and marketing or from being influenced.
That's not
by
what I'm
business
asking. The
considerations.
sales force decides whether to take the engagement. So if Peru pays them a few $1 million to say, just don't even get your credit rating analysts involved, don't let them look at it, don't take the engagement.
He's got the question. Do you have the answer?
In addition to the rule, there's a required certificate to accompany each rating action that says there was no influence of the
This is a non-rating action, sir. You're avoiding my question. The answer is obvious.
Okay. Thank you. The gentleman.
Everybody's back.
Ms. Wagner is recognized for 5 minutes.
Thank you, Mr. Chairman. Director Flannery, as part of last year's transportation bill, one of my bills was included that would allow small reporting companies to incorporate by reference any post-effective amendments on the Form S-1. The SEC, when implementing this provision in January, estimated that over 70,000 work hours and $85 million would be saved annually by small businesses. Clearly, this is a huge benefit for small companies. However, in February, I wrote a letter to the SEC asking for a similar analysis on the effects of expanding the availability of Form S-3 for smaller reporting companies, regardless of public float or exchange traded status. This is a provision of a piece of legislation that I sponsored and which has been passed out of this committee. Unfortunately, the response that I received to my letter was wholly inadequate and didn't indicate whether such a review or study would actually be done. Dr. Flannery, would you commit today to performing that kind of analysis of the benefits of this provision for small companies and providing a more detailed response?
Well, I'm sorry, but I never saw your letter. I don't know who went into what went into the response. One of the things that concerns me about reducing reporting from small companies is certainly that there is room for there to be waste. But there's also evidence that companies that go to the markets with less information are less likely to be traded. And a secondary market trading for stock is ultimately what companies would like to have if they're going to have access to capital. But to get back to your immediate point, I have a number of current policy things that we need to deal with. I would be more than happy to consider doing.
I would really like you to take
things.
a look at this. Facilitating capital formation obviously is part of the SEC's mission, and this is a provision that has appeared in that SEC's Forum on Small Business Capital Formation annual report several times. I think we can really find common ground here, and I would ask Dr. Flannery that you all commit to performing this kind of analysis. I will make sure that you get a copy of my original letter. I'll make sure I send it directly to you. Moving on, I'd like to obviously discuss the extent that the SEC and the Department of Labor coordinated in crafting their recently finalized fiduciary rule. According to email records outlined in a recent Senate report, and Mr. Chairman, I'd like to have these entered into the record, it seems that the Department of Labor disregarded advice from the SEC, specifically regarding concerns raised by the Division of Economic and Risk Analysis. In fact, a specific quote, and these are fascinating reads, a specific quote from an economist at the Department of Labor states, "We have now gone far beyond the point where your input is helpful to me." These exchanges between the SEC and the DOL should make for very interesting reading. From your perspective over the past year, sir, from the proposed rule to the recently issued final rule, how well has the Department of Labor coordinated with the SEC?
We certainly had opportunities to provide technical assistance. I am familiar with the email you described because it involved one of my staff.
Yes.
The staffer from DOL had also been a friend and a professional acquaintance of this fellow for a while. So I think what you're seeing is the culmination of a long stream of emails. Economists can be pretty direct. You know, if somebody says, "I understand what you're saying, but it's not applicable to my case. I don't want to hear any more about it." That's kind of the way I interpret that email.
Well, there are others here too, and I don't see the Department of Labor being open to any of your advice from I think, a very fine office that you run, and certainly, I have great concerns. I want the DERA to do an analysis and an impact of this DOL rule as it stands right now. Is that forthcoming?
When and if, and I hope it's when, the Commission considers a rule for fiduciary standards in our space, we will look carefully at the DOL rule because that will be part of the baseline. We always start with the baseline. What is in existence?
Well, it's your jurisdiction, sir. Honestly, it is, as laid out very perfectly in Dodd-Frank, Section 913. And, we want you to do your own uniform fiduciary rulemaking here. This is your purview, your space. You are the regulators, and including FINRA. And I really encourage and would like to get a commitment that you're willing to do a cost-benefit analysis when doing this.
Yes, absolutely. That's always part of one of our economic analyses for a rule.
Thank you very, very much. I look forward to working with you as we move forward.
I look forward to getting that. Thank you.
The gentlelady yields back. The gentleman from Texas.
Thank you, Mr. Chairman. Mr. Butler, could you please describe the statutory requirements for the annual examinations for NRSOs?
Yes, sir. The annual examination is required to cover 8 specific review areas, and it also requires that we conduct an exam of each of the NRSROs registered with the SEC. The 8 required review areas are informed by the risk assessment process that we use internally. The risk assessment process takes a variety of inputs, information from the prior exams. It takes inputs from the media. It takes inputs from the other offices and divisions of the SEC, as well as tips, complaints, and referrals that we receive on the SEC's TCR line. The risk assessment process is then used to effectively differentiate risks by registrant, which are then informing the exam scoping, which allows for our exam teams to then be most effective as they go through their examination process. We also have the examination teams arrayed in such a way that we have, if you will, larger examination teams examining the larger registrants and smaller examination teams for the smaller registrants, so that we have an effective allocation of resources. As a result of the examinations, there is a report given to each of the registrants specifically identifying the deficiencies that we've noted. And there's also a summary report that's required to be put together by the office, which is assembled and reports publicly a summary of all the essential findings that we found in the examinations.
Do you think there's room for improvement on the present requirements?
I think we're doing a very good job and a very effective job with what we have. I also believe that we can always do better, and which is one of the reasons why from a budget request we've added an additional request for 2 headcount in FY17 who would be used as specialized examiners, because I think having specialized examiners would allow for us to be able to go narrow and deep specifically on particular issues that arise perhaps during the course of an examination, perhaps elsewhere, at other times during the course of the year.
Do you think it's necessary for those exams to be annual and for your folks to be present?
I think it's important at the stage that we are right now with regard to oversight of the credit rating agencies. We've seen real change as a result of the examinations conducted and real change implemented at the firms as a result of the recommendations that accompany our findings. But for the fact that we're in there with the regularity that we are, I would not be able to sit here today and say with such conviction that there was real change. I think the annual requirement, though, is one that allows for us to bring a different approach each year to focus on different areas within the firm, so that we're not going in on a predictable basis, but rather on a more tailored basis for a particular firm with regards to risks that have been identified to us or that we've seen.
If you could scale or tailor the current requirements, what would you do?
I'm sorry, could you repeat the question?
If you could scale or tailor the current structure, what would you do?
I'm comfortable with the structure as it's currently crafted.
Mr. McCasey, the written statement notes that your office authorized to award whistleblower is in a range of 10 to 30%. Why is the threshold not 0?
I think if the intention is to incentivize individuals to come forward if they're aware of wrongdoing, I think if the calculus that individuals go through to decide whether they're going to report something to a regulator is very complicated and has a lot of factors. And amongst them, I think, is how much is in it for me, or could be how much is in it for me. And if it is true that when a person making the calculus of whether they should approach a regulator, one of the outcomes could be that they get 0, that could change and affect negatively their incentive and their enthusiasm about coming forward. And so I think it's appropriate to not have 0 as the baseline, so that individuals who may otherwise be reluctant to come forward know that there's at least a possibility of some monetary award.
What's the current value of the whistleblower fund?
Just over $400 million.
$400 million?
Correct.
So what kind of internal controls do you have in place that, respect to that fund? That's a pretty sizable amount of money.
So we can only make payments when the commission approves it, and there's a process by which we pay only against what we can confirm has been collected, and so we have internal controls to make sure that the cases that have been deemed to be worthy of an award, we have the documentation requirements that we receive documentation either from the court or from the appropriate person inside the SEC to verify that we've actually collected the money, and then we multiply that against what the percentage that the commission has approved.
Does the SEC Inspector General or the General Accounting Office audit those funds?
Yes. On an annual basis, the GAO audits the Investor Protection Fund.
Thank you. Mr. Chairman, I'll yield back.
Gentleman's time has expired. We have been called for votes. We have 5 minutes left on the vote, so those members not here should run over. This is on passage on the bill. I think there's only 2 votes, if I'm not mistaken, and I believe there is 1 or perhaps 2 other members who were here who will be returning after votes for final questioning. So you are, the committee is adjourned until to be reconvened immediately after votes. Afternoon. Hope you appreciate your little break. The committee is called back into session, and at this time recognize gentleman from Pennsylvania for 5 minutes.
Thank you, Chairman Garrett, for permitting me to participate in this hearing. This is a really important hearing. SEC oversight of the credit rating agencies and the United States Congress oversight over the SEC, especially as it relates to consumer protection, because each of the witnesses in their opening statements pretty much indicated one of the foundational principles of whether it's the whistleblower section, Office of Credit Rating Agencies, that investor protection is sort of central to what you do. I've been following a couple of issues that are the subject of the hearing today. The first, actually, slightly separate issue has to do with foreign companies that somehow get listed on the stock exchanges of our nation. They end up being fraudulent companies, many of them Chinese companies. We then find out that they're nothing but shell entities. A lot of U.S. investors have been hurt significantly. And I'm not going to ask the members of the panel to address this, but with the chairman's permission, I'd like to write to the members. I'll do it through the chairman's office. I'm concerned that either the SEC and or the United States Congress or us working together are not doing enough to protect investors. And so I want to follow up on that issue. But today I want to follow up on the issues that were raised by the members, Mr. Lynch and Mr. Sherman. Mr. Lynch is concerned, as am I, that we're not doing enough to stamp out conflicts of interest within the credit rating agency sector of our economy, of the financial services industry. We have a lot of work to do there. Mr. Butler, in response to Mr. Lynch's questions, you indicated, that in terms of full, compliance with new regulations that are being issued by the SEC, that you see this more as I think you said a journey rather than a destination. I would hope the destination is full compliance with all the new regulations, including stamping out all conflicts of interest. Maybe you can explain what you mean by a journey rather than a destination. I would hope the journey is pretty quick and that we're not adrift in that journey. What did you mean by that it's more of a journey than a destination?
What I meant by that, Congressman, is compliance isn't an end state with that companies achieve, and then compliance is over. I view compliance as something that's needed every single day. The firms have large compliance staffs. They've been adding significantly to the numbers of their compliance staffs. They've been conducting reorganizations internally to effect enhanced compliance. And what I meant by saying it's a journey, not a destination, is that this is a continually evolving necessity. As the industry changes, as the types of products change, the types of compliance that's necessary within the firms may itself need to change.
Certainly you're concerned about conflicts within, especially the big three of the credit rating agencies, since those big three, they account for what, like 80% of the market?
We're very concerned about conflicts of interest across all the 10 registrants that are registered with the SEC.
I want to follow up on Mr. Sherman's questions about this Peruvian issue. Certainly, you've seen the newspaper stories and the advertisements about the agrarian land bonds. You familiar with that?
I'm familiar with some of the media coverage about the bonds.
Can you explain to the committee what your understanding is of the conflict at this point?
With regard to the Peruvian bonds, I really don't have any particular details other than what the media reported, and it had to do with two of the rating agencies, one of which is registered with the SEC for sovereigns and one of which is not.
Mm-hmm. I'm looking at a Standard & Poor's Rating Services. This appears to be an analysis of the Republic of Peru done about 6 months ago, September 2015. Seems to have rated as investment grade with a stable outlook the sovereign debt or the bonds of the Republic of Peru. But you're familiar that there are other bonds issued by the government a couple of decades ago that are in default. You've heard that, correct?
I've seen the media articles on it. It's been a while since I read the media articles on it.
And you're aware that these same rating agencies are not willing to rate that debt for some reason? Are you aware of that?
Again, it's been a while since I've read the media coverage on it in this particulars.
With respect to this particular issue, what are the circumstances that a rating agency should be permitted to rate, new sovereign debt and get paid to do that, and that's part of their business model, we understand that, but ignore the requests of the investor community to rate other debt issued by the government that's in default? How is it the rating agencies get to pick and choose what debt they're going to rate and what debt they're not going to rate, especially when it affects small investors in the United States of America?
The rating agencies are required to establish, maintain, and enforce policies and procedures to address their conflicts of interest. And within that, there are conflicts of interest identified, which would be disclosure-based, and others that are absolutely prohibited. The prohibited conflicts would include the
But
separation.
what kind of discretion does a credit rating agency have to just decide on their own what they're going to rate and what they're not going to rate?
With regard to our oversight, Congressman, we look at the work and the work product that's been done. We don't have authority with regard to the substance of ratings or the procedure methodology.
I'll tell you what my concern is. My concern is that there are pension funds in half the states in this country that have invested the retirement savings of police officers, of firefighters, of building construction trades workers, average everyday Americans who are losing money in certain investments where Standard & Poor in this particular case has said, yeah, Republic of Peru is investment grade, but they're in default on other bonds. And I'm concerned that they're deciding what bonds are going to rate and what bonds are not going to rate, because if they rated these land bonds that were issued a couple decades ago and found out that they're all in default, that would affect all of the other ratings that they've issued. And that may have an effect on the ratings, not just of the Republic of Peru, but other corporate bonds that they've rated also within that governmental area. So I would ask you to take a look at that and question the rating agencies, 4 or 5 or how many there are, not very many, not enough, I would say, and question them as to how they're using the discretion, what to rate and what not to rate, whether there's a conflict inherent in that decision, and how many small investors, how many working class Americans are being affected, negatively impacted, losing retirement savings as a result. Would you do that for me?
Thank you, sir.
Would you do that?
I'm not at liberty to discuss the substance of an examination, but I'm happy to take your comment under advisement.
I'll follow it up with you. Thank you. Thank you, Chairman.
Thanks. And before I call on the gentleman from Maine, I just want clarity as to one of the answers on that. When you say that there are already rules in place as far as the conflict of interest for what the decision by the rating agency, I think I understand what you're saying. But that conflict that they have is on the, that conflict that they have to make sure that there isn't a conflict of interest is on the, going forward, the decision on the entity that they're going to be rating tomorrow. So if they're rating the XYZ country or entity over here, they have to make sure there is no conflict in that decision, right, is what you're saying?
The new rules that were adopted in August 2014, effective June 2015, require there's a certificate with regard to any rating action. The rating action could be either a new issuance or a surveillance of an old rating.
Right. But it doesn't go to the point that the gentleman from Pennsylvania was making as far as their decision not to rate someone. There's no question. You don't look to see whether there was a conflict of interest when they decided we're not going to rate X, Y, and Z. Is that correct?
As it's currently crafted today, we're looking for surveillance activities and new issuance activities.
Okay. Thank you. With that, now, last but certainly not least, the gentleman from Maine is recognized for 5 minutes or so.
Thank you, Mr. Chair. Appreciate it very much. Mr. Wyatt, you represent, or you are the Director of the Office of Compliance Inspections and Examinations for the SEC, correct, sir?
That is correct.
Okay, and the SEC has about 4,000 employees and about a budget of $1.6 billion last time I looked.
SEC-wide, that's
Right.
correct.
Yes, exactly. And of those 4,000 employees, 1,000 work for you.
1,011, yes, sir.
Okay. I represent Maine's 2nd District. This is western, central, northern, and down east Maine. It is the most wonderful part of the world. If you haven't vacationed here, Mr. Wyatt, I know you're going to want to take your other associates with you to go vacation here this summer, which is upon us. We have a little bit of snow in Aroostook County, but it's melting. Now, we are a district of small business owners. We're a district of small savers, hardworking people, honest people, people putting aside 50, maybe $100 a month to save for their kids' college education, or maybe for their retirement. Now, your job at the SEC and all your jobs is to make sure that there's integrity with respect to our publicly traded and other securities, to make sure our investors have a fair shake at knowing what they're investing in. Now, help me out, if you don't mind, Mr. Wyatt. Your budget goes up for the entire, not just yours, but your part of it. For the SEC, you always come back to us every year for more money. And I think you asked for another 10 or 15% from last year to this year. So my question is, with 1,000 folks in your staff, how many inspections, how many examinations per inspector do you folks conduct for our registered investment advisors, the folks that manage our pension funds and our 401k funds and IRAs? How many examinations per inspector per year?
The average is 6 to 8 per examiners. I would highlight that we do not conduct examinations on an individual basis. Our examiners go out and examine investment advisors in teams.
Right.
The coverage rate.
Okay. Yeah. 6 to 8. Okay, but you ask for an increase in your budget every year. What was the number? How many examinations did your teams conduct the year before?
Last year, we conducted 1,992.
No, how many per inspector, Mr. Wyatt?
Per inspector, we've had a 23% increase in the number of exams per examiner in the past 3 years.
Okay. Okay, thank you. I appreciate that very much. Let's continue to drill down a little bit on these examinations, sir. I know that the administration's financial regulations ask you to make sure that you conduct robust examinations of the investment advisory space. And if I'm not mistaken, there are about 14,000 registered investment advisors in America. Have I got that right?
Roughly 12, yes.
Roughly, okay. Do you think that you folks have spent a disproportionate amount of time recently on the private equity space? In other words, the type of investment advisor that deals with more accredited investors, larger investors, more sophisticated investors, as compared to folks who don't make a living investing, but might be nurses or teachers or folks that work in the forest products industry in our district. Do you spend a disproportionate amount of your time, sir, on the private equity examinations for large investors as compared to the investment advisory space for smaller investors?
I would suggest that those large investors that you're referring to are the endowments, institutional investors, and pension funds. Those pension funds are investing on behalf of the firefighters, the police officers, and teachers. I would say with regards to our examinations of private funds, we've been very efficient in the resources we've dedicated to them. When they came into registration with the SEC as a result of Dodd-Frank, we conducted the Presence Exam Initiative. When we had focused, limited scope examinations of private funds, those funds uncovered some activities regarding fees and expenses and allocation of trades that resulted in funds being returned to those institutional investors who, again, are investing on behalf of the firefighters, policemen, and teachers.
But I think you would, and I appreciate that, you want to make sure that your scope of examination spans all investment types, and I understand that. But Mr. Wyatt, wouldn't you agree that it's incumbent upon us to make sure we look out for the small saver, the small investor, whereas those that are make a living in that business are usually better able to get the information they need to make their investments?
Well, we certainly want to protect investors. We certainly are doing our utmost to increase our exam coverage. I would highlight to you, as a result of our examinations of the private fund, many of those institutional investors have come to OC and asked for our assistance in how they can improve their due diligence, because we got access to information that they otherwise wouldn't get in the course of their due diligence. So we're sharing that information so those institutional investors can be more informed when they make investments. And we're also doing our utmost to expand our coverage ratio within the investment advisor space. We get to roughly 10% a year, roughly 30% of the assets under management. We hit a 4-year high with regards to the number of examinations we've done, but in a 2-year period, we've had a net increase of advisors of roughly 1,000. So we're continuing to increase our numbers. We certainly want to dedicate resources to improve our efficiencies. We certainly want to make sure we're doing our utmost to protect investors.
Thank you, Mr. Wyatt. Mr. Chair, if I may just continue with one line of question, please, sir. I am the last here. Do you have another question? Yes, sir, I do. Thank you very much. Thank you, Mr. Chair, and thank you, Mr. Wyatt. Mr. Wyatt, what would be a great help to me in my office in representing our 2nd District of Maine, and also, I'm sure, to our committee and the rest of the country, when you're dealing with such an important part of our capital markets, you must have in your department a written set of procedures such that we, that is responsible for oversight for your entity, can make sure that we know exactly how you're conducting your business, exactly how you make your decision on what inspectors go where, and what the expectation is for the number of examinations, just to make sure when you folks come back to us and ask for more money, we know that the taxpayers are getting, the right bang for the buck. Would you be able to provide that procedural guidelines to us?
We are doing our utmost to be as transparent as possible.
Do you have a set of written guidelines, sir, that
We have a guideline. We have an exam manual that we use that's private.
Yeah, but that's for the examinations. I'm talking about for Congress that represents the people. Do you have a set of procedures that articulate exactly how you conduct your examinations?
That's our exam manual that guides how we conduct our examinations, yes.
Okay, and can you add an addendum to that such that we know what kind of activity, the amount of activity for the money that we're spending on behalf of your organization, such that taxpayers know that they're getting their money's worth?
We can certainly liaise with your office to try to provide you with the information that you're seeking.
That'd be great, and we'll be in touch with you. What's today? Today's Thursday. We'll be in touch with you tomorrow.
Look forward to it. Thank you.
Thank you, Mr. Wyatt. Appreciate it. Thank you, Mr. Chair, very much.
Thank you. Since no one else is here, I can just go on for hours here, but I won't. The Vice Chair, and I'll just be two quick questions just to drill down back a little bit on something else. I think Vice Chairman Hurt raised this question, Mr. Flannery, as far as taking a look back at, doing a look back at past rules and how that's all supposed to work and what have you. Can you just spend 30 seconds? What's your game plan, what's your goal, what have you, to look backwards towards the last half a dozen years of rules that have been promulgated over the last half a dozen years and to see whether they're all working and what have you?
Well, of course, one of the biggest ones, one of the biggest sources of rules over the past half dozen years has come out of the Dodd-Frank Act.
Right.
And I know that the Congress is concerned about the cumulative effect of the Dodd-Frank rules and regulations on liquidity in financial markets. So DERA has been charged with doing a study on that very thing. I think it's a terrific study to be doing. We've started. We haven't gotten deeply into it. But the question of how liquid are our financial markets, particularly maybe the debt markets, I think has very important policy implications, both here and around the world. And so we're looking forward to doing that. And the impact of these cumulative regulations on that liquidity is going to be an important conclusion. An assessment of that is going to be an important conclusion of our study.
Okay, and of course that always begs the question as to when.
Well, you've told us, which is that that we'll get back to you within a year of the Omnibus Act last year being passed. Yeah. I think that's our first draft, and 18 months is the final draft.
And that will look into also, besides those 2 points, we'll look into I'll say the cost, economic impact on the industry and the marketplace?
On the liquidity, as I understand it, is what you're primarily interested in.
Well, yeah, that I get. It'll look at the liquidity, but it will also look at the overall cost. I mean, what is the economic cost measured in dollars and cents to the industry per se? It's costing us, this firm, X millions of dollars to do it, and this firm X million dollars. So what the total cost? That may or may not impact always upon liquidity, I presume, right? It costs another $10 million to do so, but liquidity stays the same. So right. You're doing liquidity over here. That's good. Are you also looking out to the overall nominal cost, I guess is the word?
Yeah, I think the nominal cost would be the word, and that would certainly be a part of that study. Okay. A part of any economic analysis is to set a baseline, and the baseline would include considerations of the cost of operating today, absolutely.
Yeah, and I'll end here where you began with one of my very first questions. So I've heard some good things as far as what you're talking about here from industry and otherwise, as far as in one of your opening comments and was talking about how some of this information is now being put out as far as your studies and what have you presented. I'll put it in this way. Is that as far as you can go, or can you improve that? Can you reveal, I don't know what the right word is here, can you reveal more information as far as the methodology, the data points, and everything else that goes into it? And I ask that question because some folks look here and say good, but look other agencies and how they do their analysis that you do in their area, and they put out a fuller, more complete, more in-depth background, if you will, onto that. Do you see a comparison? Maybe I should put it that way. Do you see a comparison to other ones, what you do, and do you see that you could do a little bit more or more in these areas? That's my last question to you.
One of the things I've been working on in the past year and a half since I got there is the idea that we bring in all this registrant information. It's treated as confidential and private because the registrants don't wish to be identified for obvious reasons. But that shouldn't interfere with our ability to provide information about various aggregated forms of that information.
Okay.
If we're going to be useful, we've got to tell people how we made the decision about the
Right.
aggregation.
Exactly.
So I agree with you entirely about that.
Okay, and so you're going to be, you're going to be working on?
Yes.
Okay.
Yes.
With that, that's good. So with that all being said, I thank the members of the panel and all the witnesses here today. The chair notes that some members may have additional questions. As you see, we keep on, for the panel, which we will be submitting in writing. Without objection, the hearing record will remain open for 5 legislative days for members to submit those written questions to you, the witnesses, and then for us to have that responses placed on the record. And also, without objection, members will have 5 legislative days to submit extraneous material for the chair for inclusion in the record. And I would be remiss if I did not add this, that if you can't make the trip all the way up to Maine, the snow is already gone in New Jersey, and things are blooming already in New Jersey. It'll be another 6 months before the snow and the ice melts in Maine. So with that, this hearing is adjourned.